Hi, I'm Greg Dell with Attorneys Dell and Schaefer, and I'm here with Attorney Stephen Jessup. And today we're going to discuss a case against Prudential Insurance Company that was a lawsuit out of the California Federal Court. Fortunately, it was another victory for the claimants against Prudential. It was not a case that our firm handled, but as you know from watching our videos, we report on all of the cases around the country, and we think that this one had some great information that will be helpful for claimants nationwide when bringing a claim against Prudential. So Steve, give us some information about this case, and then let's talk about some of the positive takeaways from this case that will help many other claimants in the future.
I think the biggest thing I need to start with on this is the context of the lawsuit itself. This was filed in the Central District of California. California is rather unique in the way that they review ERISA disability insurance claims as opposed to other parts of the country. They employ what's known as the de novo standard of review, where a judge is only tasked with determining whether or not the plaintiff, the insured, met by a preponderance of the evidence that they're entitled to benefits under the policy. This was a particular case I found very interesting. The client, or the insured at the time, prior to filing for disability, she worked for Chase as a client relationship manager. So she was in charge of financial aspects, meeting with clients, all kinds of revenue type situations, things that the court noted were highly cognitively demanding. Her conditions range from chronic headaches and then secondary anxiety and depression, just dealing with this constant throbbing pain in her head. At the recommendation of her doctor, she filed for disability because she was having a hard time concentrating at work, in situations with numbers, recalling of information, things that could really greatly affect the clients that she was servicing. So she had a very executive level type job. Unsurprisingly, Prudential denied her application. In doing so, they made a very standard argument that there was a lack of objective evidence to support restrictions and limitations. They also noted from the depression and anxiety side of it that she was able to perform her activities of daily living, that she had to travel out of the country to handle a family matter. These things that made it seem like she was okay, that she should be able to work.
I want to ask you a question because for us, it's unsurprising. To many people who contact us and who are looking for information about, chronic headaches, you said unsurprisingly denied her claim because she had subjective evidence. I mean, what else would she have besides subjective evidence when dealing with chronic headaches?
And that's one thing that the court eventually stated, that it's inappropriate to require of an insured objective medical evidence, such as MRIs, nerve conduction studies, CT scans. Those are objective sources of medical evidence. It's inappropriate to require that when the condition is subjective in nature, a pain condition, headaches. They also say how it works with fibromyalgia, chronic fatigue. So this idea that you cannot require evidence that is not in existence to even provide. She went through the appeal process. Prudential upheld the decision based on reviews done by hired medical professionals, and then the lawsuit was filed. When it got
the court said it's not appropriate to require objective evidence when there is none. I want to caution some people, though, that there are policies that we see where they do require objective medical evidence, and had this policy had that kind of language, this might have been a totally different case.
And one other interesting thing that wasn't brought up, since the whole case was surrounding her cognitive ability to do it, there wasn't one mention of neuropsychological testing done. There wasn't seem to be indicated that Prudential's attorneys argued there was no way to verify these cognitive problems outside of her report to the doctors. That was another thing that could have really changed the landscape of the case. So with this in the court, some of the great takeaways in this is the court said, due to the fact that the policy is focusing on the ability to perform the material and substantial duties, which a lot of policies have language like that, you must look at the functional capacity, the functional information available, and not merely a diagnosis. And a lot of time insurance companies will just look at a diagnosis, they'll kind of write it off, and also then go, and this is very common if you've received a denial, if you have an executive level job where you're getting paid to think essentially, they will say, well, you can still do a sedentary job, you can still work this desk job. Her headaches weren't preventing her from sitting at the desk per se, it was preventing her from actually doing the tasks that get her paid. So the court was saying that that is more important. We look at the symptoms, not just diagnosis, and what's in the records and the doctor's reports to show what would prevent her from working. Going through the medical evaluations performed by her doctors, the court also noted that under the standard they were going to employ, this de novo standard. They didn't have to give deference to the insurance company's reports, and that in California you give more weight to a treating physician who's actually examined someone as opposed to someone who's just reviewing a file in most cases. So they took a look heavily into her medical records. And the court came out with an ultimate conclusion that they believed that there was, by preponderance of the evidence, enough information to support, based on how much treatment she was getting, the opinions of her doctors, that she would not be able to do the cognitive demands of her job. She may physically be able to be present body at work, but that in and of itself was not performing these material and substantial duties. So they found in her favor based on that. So in most cases that may come out, that we see analysis, if there's that arbitrary and capricious standard, the court has to defer to the insurance company's review. They're not just making a call, do I find this person disabled? They have to, one, find that there's evidence of disability, and two, show that the insurance company acted arbitrary and capricious, or they didn't have a reasonable basis to deny the claim, things along those lines. So her being in California certainly helped with this outcome. It wouldn't apply to people, everywhere in the country, but there's at least good arguments to be made. And it also shows that, Prudential's conduct in California, the way they review, it's the same way they're going to review the case if you live in Vermont, Idaho, Florida, it doesn't matter. They're going to do the bare minimum with reviews, and more often than not, they're going to really overlook what the actual duties of a job are and strip it down to this idea of what's the physical demand level of the occupation.
Right. Well, the problem is with Prudential and many of these other companies, it's pretty consistent, is that the claim rep who's assigned to the claim just sends the file out for a medical review, and whatever that person says in the medical review, Prudential's going to adopt. And I shouldn't say whatever, because if they got a finding that said the person is disabled, I've seen them then say, well, one doctor said they're disabled, let's get another one to see if maybe they can say they're not disabled. But as soon as they get someone who says, yeah, you are not disabled, they're just going to adopt it and say, here's the letter, cut and paste from that report, and deny the claim. And that's what happens in 99% of the denials.
And the court even pointed out, and this is true when we review a lot of the peer review reports in a claim file, the reviewing doctors didn't even have any idea what the person did for a living. There was no job description, understanding of the duties, so they're just merely looking at records and not putting it in the context. Like we always argue, the insurance company argues, a diagnosis doesn't equal disability. You have to show that there's a restriction. So how can a doctor just review records without having the context of what the person must do for a living based on what their medical problems are?
Right. So this is a classic denial. They're hoping that the claimant's just going to go away. Fortunately, this one didn't, and this one battled them, to go the distance and was victorious. Now, did the court remand and award benefits, or did they send it back to Prudential to reevaluate?
No, they awarded benefits up and through. In this point, there was a return to work date noted by one of her doctors in the claim file. So the court only awarded benefits up to that return to work date. I think it was like 11 months. And then further evaluation had to go back. Another interesting point on here, because we do have depression and anxiety as a diagnosis, Prudential tried to get the court to determine if this was a mental health condition subject to 24 months. Or into any occupation. The court said that's outside of our realm. We're only looking up to the time of the denial and the information we have, and we're only going to do it there. So they did send it back for a review. Another very interesting thing, since we also know insurance companies are going to require you to apply for Social Security, the insured applied for Social Security, but she was denied. Prudential, when dealing with the award of how much they owed her, tried to argue, well, we should be able to offset for Social Security because she didn't pursue it. And the court said there was no indication in the claim file that you advised her she needed to appeal that decision. So I'm not allowing you the benefit of offsetting her benefit now under the terms of the policy. So there's still some things left up in the air, but at the end of the day, the court was approving benefits up to a certain point, and then Prudential was going to take back over the review again.
And then even though this person only went for 11 months of benefits, this case was probably 3 years post the date of disability. Now this claimant has to go back to Prudential, reevaluate, hope that she's going to get the 2 years if she's still out of work. And if Prudential says no now, she has to appeal again, file a new lawsuit, and do the whole damn thing over again. So we obviously don't know the status of what happened. But
or even the policy language. Prudential writes a lot, 24 months for self-reported symptom conditions,
right,
which headaches tend to fall into as well. So there's still a lot that could be happening or has happened, but we don't know, because with these ERISA claims, you're always in this snippet in time.
Right. Well, if you have a case with Prudential at any stage, whether you're applying, appealing, or need to file a lawsuit, feel free to call any of our disability attorneys. We're available to help you anywhere in the country, and we look forward to the opportunity to work with you.